Senator McDougall.
Well, I just want to thank the Minister for her kind words and to express my happiness that the legislative process has addressed the difficulties that arose from the interpretation by the Court of Appeal of the Children Act 2001, and in particular Section 252 of it. I think everybody wanted to, and the Court of Appeal invited the Oireachtas to look at this issue if it was unhappy with the outcome of their decision. Everybody wanted to reverse, to some extent, the implications of that decision. But you know, some people may have thought that the decision itself was a bombshell. It seems, though, technically to have been correct, and so that shows that it's important that when we legislate in this House, we look very carefully at what we're doing. But it was rather not so much a bombshell as an unexploded bomb, and the problem was that it had to be dismantled in a way which actually preserved other very important and vital safeguards. And I just want to make 2 points in respect of that. Firstly, for instance, supposing, and this happily I don't think has happened ever, an intruder broke into a house, murdered one child and raped another child, it might well be that the court proceedings, if you start naming the deceased child, the victim of the murder, you might end up identifying what happened to another child in the house. So, I mean, this kind of strange situation can occur where the interests of two different children who are part of a horrific set of circumstances may have to be balanced by the court in a way which isn't immediately obvious if you just look at this matter on the basis of first principles. So I welcome the fact that flexibility has been introduced here and that the court has to balance a number of rights and conflicting interests in a situation such as that. And there are other much more mundane matters where child victims of other crimes are covered by Section 252, and child witnesses who testify in such cases, their rights have to be protected as well. So changing the law wasn't as simple as was thought at the very beginning, and I acknowledge the efforts of the Department of Justice and the Attorney General's Office to get the balance right. The second point, and I just want to make this a point very briefly as well, Curlig, is this, that the law in Section 252 is fairly narrow. It talks about reports of court proceedings not being broadcast in such a way as identifies individuals. And it doesn't, and I think this is something which should be borne in mind, it doesn't prevent the parent of a child who was murdered from afterwards saying, my child was murdered. The law is strictly concerned with reports of court proceedings. So whereas the media are constrained and people are constrained from saying things about it, in the end, the law doesn't say that I can in any circumstance ever be inhibited from saying that my child was murdered, if that is in fact the case. And that's an important point. Nor does it actually, on the face of it, prevent me from ever saying who did it, as long as I am not purporting to report a court case. So I'm just making the point that people interpret our law in a way which is perhaps slightly overly strict. The Jamie Bulger case in England preserved anonymity for the alleged perpetrators or the perpetrators of that terrible crime into their adulthood and all the rest of it. But in fact, the Section 252 doesn't go to that, isn't that rigid. It doesn't say that somebody can be, so to speak, screened from the fact that they murdered somebody for the rest of their lives. All it says is that particular court proceedings, reports of them cannot be published in a particular way. So having said that, and I say that because I think it's important that you know, whatever decisions a court may make about the reportage of an individual case, it is not the case that in any circumstance the parent of a child could ever be afterwards denied the right to say that their child was murdered. That simply will not be the law in future, or to name the child in that context. So I want to finish by thanking the Minister, thanking Deputy Jim O'Callaghan, and thanking the Attorney General's Office and the Department of Justice for the very careful and reasonable way that we have tried to craft this legislation to balance all those rights, and to say that I hope that what we are doing will, in early May, as the Minister says, lift what was an unjust situation from the shoulders of bereaved families. We had the odd situation that the victim of a crime in the East Wall in Dublin was named, but then as soon as court proceedings started, the cloak of anonymity seemed to come down on that situation, and the media found themselves in a peculiar position that they couldn't actually identify the child who they were speaking about 2 weeks earlier as being a child mentioned as a child affected by the particular crime. So I want to thank the Minister and express my appreciation that the legislative process has worked slowly perhaps, but very carefully, because what we were doing was dealing with one unintended consequence of legislation 20 years ago, while very, very careful to ensure that we didn't produce further unintended consequences in a rush to rebalance the situation. Thank you, Ciarán.